All right, good evening and welcome to the next in our Know Your Rights series. Tonight, we're going to be talking about eviction rights. My name is Sarah McKenna. I'm an attorney at Dinsmore and Shohl, and I'm here representing the Louisville Bar Association Public Service Committee. Also moderating with me is Michelle Duncan. She's also a partner at Dinsmore and Shohl. And Michelle, you want to introduce yourself and say what organization you're representing?
Sure. Everyone, I am representing the Charles W. Anderson Jr. Bar Association, formerly known as the Louisville Black Lawyers Association. Our organization, in conjunction with the LBA Public Service Committee, has done a series of Know Your Right forums throughout 2021 as well as 2020. And this is our latest installment. We have an excellent panel to speak to you tonight to answer any and all questions that you have about evictions.
Thank you, Michelle. So our panelists tonight include Stewart Pope, Advocacy Director at the Legal Aid Society of Louisville, Ben Carter, an attorney at the Kentucky Equal Justice Center, Marilyn Harris, the Director of Louisville Metro's Office of Housing, and Gretchen Avery of Avery and Sherman. I'm going to invite each one of our panelists to introduce themselves and say a little bit about where they work, what they do, and their relationship to this program. Ms. Harris, let's start with you.
Hi, I'm Marilyn Harris, and I'm the Director of Louisville Metro Government's Office of Housing. And historically, we have done things like the home repair program. We work with developers to develop affordable housing. And we work with the down payment and closing cost assistance program. We run that for the city. However, we are currently running an eviction diversion program in Jefferson County Courts that provides rental assistance for persons facing eviction. And we've been doing that since August 24th when the courts opened back up.
Thank you so much for joining us tonight. Mr. Pope.
Hello, I'm Stewart Pope. I'm the Advocacy Director at Legal Aid Society. If you're not familiar with legal aid, we provide free legal service in civil cases to people who can't afford an attorney. As Advocacy Director, I kind of oversee all of our legal work and provide support to all of our attorneys and legal staff in the work that they do. My relationship to this program is that I have, my background is in housing law, and at Legal Aid, I have worked in eviction and foreclosure defense, and that's kind of my area of specialty.
Great, thank you so much for being with us. Mr. Carter?
Yeah, hi everybody. My name is Ben Carter. I'm an attorney for the Kentucky Equal Justice Center, and that's a statewide nonprofit organization that works across a number of different areas of law, including housing, workers' rights, health, and immigration. We work closely with our legal aid partners, the 4 legal aid organizations across the state, but we also lobby for people in poverty in Frankfurt, work in communities all across the country, or excuse me, all across the state. So my connection with this has been mostly on a statewide level, working with organizations here in Louisville and across the state, trying to improve our eviction processes.
Great, thank you so much. And Ms. Avery.
Good evening. I'm Gretchen Avery. I'm in private practice. I initially started my practice at Legal Aid, actually working with Mr. Pope in the eviction prevention program. I've been in private practice probably for 17 years now, and I do some landlord tenant work still, along with my other areas of practice.
Great, thank you so much for joining us. We will be accepting questions in the comments on Facebook. So if you want to leave a question as we're going through tonight, feel free to do so. We'll get to those at the end. Let's begin, Mr. Pope, with you. Can you give our audience an overview of how the eviction process works in Jefferson County, starting with what a landlord does to start the process going all the way through the end?
Sure. The way an eviction works is a landlord will evict a tenant for one of 2 reasons. One reason might be that the lease has just expired, the lease term is over, and the tenant hasn't moved, and they will file an eviction in that case. or the tenant has breached the lease in some other way. A breach of the lease is either going to be a financial breach where they haven't paid, the tenant has not paid the rent, or it could be a non-financial breach. And that would be a case where you've got a tenant that's disturbing their neighbors. They're playing their music too loud, or they're parking in several parking spots when they're only allowed one parking spot, or any kind of a material breach of the lease. The landlord can then file an eviction. Now, in order to file an eviction in any of those cases, the landlord has to give the tenant notice. And just to make it confusing, the notice is different for each one of those instances. So if a tenant has breached the lease and the landlord is, say, filing the eviction for non-payment of rent, they have to give the tenant a 7-day notice, which tells the tenant that you breached the lease by not paying your rent, and you have 7 days to pay your rent, or I will evict you. Now, and the important thing for a tenant to know is that during that 7 days, they have an absolute right to pay their rent, and the landlord has to accept it. So, and this is in Jefferson County. So if we've got folks listening from other counties, it may not apply, but Jefferson County has the Uniform Residential Landlord Tenant Act. And so that provides that during that 7 days, the landlord has to accept the rent if it's offered by the tenant. Now, the tenant does have to offer full payment of the rent. The landlord does not have to accept a partial payment, but they would have to pay they would have to accept full payment. If the tenant does not pay within 7 days, then on the 8th day, the landlord can file the eviction, and they do not have to take the rent payment after that time. And in fact, they cannot take the rent payment and still evict. That would waive their right to evict. So just remember that during the 7 days, the landlord has to take your rent. After that, they do not have to. The other breach is for material breach. So if somebody's playing their music too loud, the landlord sends them a 14-day notice. And that 14-day notice says you breach your lease by playing your music too loud, stop, or we will evict you. So what that means is that for 14 days, basically the tenant can play their music as loud as they want to, as long as on the 15th day, they turn it down and they are quiet. And in both cases where either the tenant has paid their rent or where they have stopped whatever activity was the material breach, that cures the breach and the landlord can't evict. Now, on a material breach, if the tenant keeps their music turned down for 3 or 4 months, but then in the 5th month turns their music back up, anytime within 6 months, if they violate the lease that way again, the landlord can evict without having to give a new 14-day notice. The last way that a landlord files an eviction is when the lease is turned out. We used to not see quite so many of those kind of evictions, but now during the pandemic, I think we're seeing lots of evictions being filed where the lease term has expired because the pandemic's been going on for a year now, and so all the leases are expiring. So in that case, the landlord has to give a notice that's equal to whatever the lease period is. Usually it's month to month, so it'll be a 30-day notice. Now, if somebody's living in maybe a boarding house or something like that and paying their rent on a weekly basis, then it would be a 7-day notice. So it's however they're paying the rent. But usually it's month to month. You pay your rent on the first of the month, and so the notice would be a 30-day notice. That notice starts to run on the first day that rent is due. So if a tenant is paying their rent on the 1st of the month. If that's the day their rent is due, if they gave notice, if the landlord gave notice today that they weren't going to renew the lease, that 30 days would not start to run until April 1st. So the lease would expire April 30th. So that's a little confusing, but it's important to know if you're planning to move at the end of the lease term when that 30 days starts to run. So that's how the process gets started. The landlord has to deliver those notices to the tenants. At that point, if the tenant doesn't cure the breach of the lease, or if the lease is expired, they can file an eviction. The eviction, by law, the tenant has to have 3 days to prepare for the hearing. As a practical matter in Jefferson County, and Gretchen would have a better idea of how many days it takes, but it takes 2 or 3 weeks from the day that the landlord files it to actually get a court date. Then you get a court date, you go to a hearing, depending on your defenses and what's going on. They might decide it the first day, it might be continued for weeks. If an eviction is entered, if the tenant is found guilty, they have 7 days to appeal. On the 8th day, the landlord can get a writ for possession and deliver that to the sheriff, and the sheriff will come sometime within the next 30 days and set the tenant out. So that's how the process works.
Thank you, Mr. Pope. The next question is for Ms. Avery, and we certainly welcome the other panelists to comment as well, sort of piggybacking on what Mr. Pope just commented on with respect to the eviction process and the number of days of notice that you have to give. Can an eviction process be altered or changed by the terms of a specific lease agreement? And just to go a little further, are there any provisions that you would encourage potential tenants to consider when thinking about entering into a lease?
Well, to begin with, the landlord or a person entering into a lease can't lease against the law. So if the law is clear as to what's required of a lease requirement or through a landlord-tenant relationship, the lease can enhance it, but it can't diminish it. So such as the notice requirements, where you have to give 7-day notice for a non-payment. You can't lease against saying, look, I'm only going to give you a 2-day notice, and if you don't pay, I'm going to file an eviction. You can't do that, but you can enhance it. You can say, look, I'll give you 14 days to pay it versus a 7-day, and I'll give you more time to do it. You can enhance anything, but you can't contract against what the law is providing for the landlord-tenant relationship. And to back up a little bit regarding what Mr. Pope was talking about regarding the 14-day breach notice, one issue that is hot and heavy since I was a baby attorney to present is, are all breaches curable? That is an argument that I often say when I represent landlords. You can't cure every breach that exists. And an example, if a tenant beats up another tenant, can you cure that? You can't take back the hits. So, I mean, that's often the issue that I will argue when I'm representing a landlord. And if there's a opposing counsel, usually it's legal aid opposing counsel saying, you can cure it. And I'm thinking, absolutely not. You can't cure shooting someone. You can't take the bullet back. You can't cure smacking someone. You can't take the smack back. So, I mean, that's always an argument that, or always an issue, I think, that's present before an eviction court. And it makes for interesting discussion. What can you cure? So, well, back to what you were asking me, though, about the leasing thing. I mean, most tenants need to realize that when they take a property, that's probably the best condition it's going to be in is when they take it. So if you go into a property saying, oh, well, this doesn't make me happy, I need this and this change, you probably just keep walking. Because, I mean, 9 times out of 10, that landlord is not going to go in there and renovate that entire property. If you sign the lease in, I'll take it as is. And so, I mean, but you'd be surprised when people think, oh, well, they said they would do it. I'm like, yeah, all right. You're right there. You sign that lease, and unless it's something that's not habitable, they're probably not likely to change it. See if there's anything else on here. So, I mean, I would think the tenants need to just be mindful, pay attention to the neighborhood, pay attention to the neighbors, pay attention to the unit. If you're not happy with any of those things, you're better off to keep shopping versus getting it and then thinking you're going to change any of it. You kind of see what you're going to get when you see it.
Thank you.
And one
Thank
other
you,
thing,
Ms.
let me tell you one other thing. I just want to throw this out there in particular, and I'm going to talk to my people who are like Section 8 tenants who are actually have the voucher through the housing authority and they're shopping it with different landlords. One thing that I have seen over my 20 years of practice that people will often do, you'll have a landlord that says, yeah, I'll accept your Section 8 lease. You know, Section 8 is going to pay, agrees it's worth $800. But I think my property is worth $1,000. So I'll sign this contract, but I want to make a side deal where you're going to pay me $200 extra so I can get my full 1,000 versus the 800. Don't do that. I mean, that's a violation of your agreement with the housing authority. It can put your voucher situation in jeopardy, and it also can put the landlord's ability to lease through that program in jeopardy. The contract price is the contract price. Don't make a side deal to pay something more because, you know, it's not a good idea.
Thank
Can I
you. That's
just-
great advice.
Eric,
Oh, go
Can I
ahead.
just jump in on what Gretchen just said? I think it's important to note that as of March the 1st in Kentucky, it is in Louisville, it is illegal to use source of income as a, you know, you can't say I won't accept Section 8 anymore. That's illegal. Source of income is a protected class in the city of Louisville now under a new ordinance. So that is important to understand. And so if you go to apply for a unit and they just say, nope, we don't accept Section 8, that is a violation of your rights. And I would encourage someone to reach out to legal aid immediately if that should happen.
And on that same note, though, you have to understand that one thing I want to put out there is that Section 8, from when I first started as a lawyer back in the days, just about any property could pass a Section 8 inspection. I mean, you could front door, back door, floor, that's all you really require. But now they have really, I think the inspections actually does the inspection of the properties now. So it's really hard for people to pass it. So a lot of landlords can't pass the inspection process and can never get approved to take that Section 8 voucher because the house isn't up to standard. So although they can't say we won't take your voucher, a lot of times Section 8 will not let you take the vouchers. Your house is not up to the quality standards they're requiring now. So that's, you know, something to be mindful of.
Thank you for sharing that. I appreciate that discussion regarding that issue. Mr. Carter, can you tell me about the lawsuit that Kentucky Equal Justice filed in federal court in February? I understand it has to do with the judicial process for evictions in Jefferson County, in particular regarding notice. And I want to ask you to explain to our audience what we as lawyers throw around as notice, and what that means. I mean, obviously, we have a lot of different concepts of what notice means, but is that snail mail? Is that a sign on the door? What is that for our tenants?
Yeah, let's talk first about notice and constitutional law, I think, and then back into the history of evictions in Jefferson County during the pandemic, and that'll get us to where we are today. Essentially, the Constitution guarantees people notice and the opportunity to be heard whenever they're subject to a process that could deprive them of life, liberty, or property. And so here in an eviction case, obviously your rental property is a property interest. And so the United States Supreme Court has said in a case that actually came out of Louisville in the 80s that the Constitution's due process rights provide a minimum amount of protection in an eviction case, right? Nobody requires the judge to show up at the home renter's doorstep and say, hey, you're being sued, come to court next week and we'll come. The question is, what is the minimum that courts and the state need to do to put someone on notice to the fact that their property interest or their liberty or life is at stake in a proceeding? And what the Supreme Court has said is it's sort of a sliding scale based on what property interest or what constitutional interest is at stake. What's the likelihood of erroneous deprivation? How hard would it be for the state to provide people with additional notice? All of these factors go into whether a notice meets the minimum constitutional standards. And so when the court opened back up for evictions last summer, it was remote only. And that's new. for everybody, for the courts, for the lawyers, for people facing eviction. And so the court started sending out a notice with all of the eviction paperwork that essentially said, come to the Zoom eviction hearing. Here's the phone number that you need to call. Here's the access code that you need to dial in when it's time for you to come to your eviction hearing. For people to appreciate the importance of getting this right, they need to understand that if a person doesn't come to that initial hearing, that's actually a trial, right? It is the hearing, the one-time chance for you to show up and tell the judge what your situation is. You can request a jury trial at that time. You might be postponed or something like that. But if you don't show up at all, you have a judgment of eviction entered against you. It's a default judgment, just like if a T-ball team doesn't show up to the field, they forfeit the game and they lose, right? That's what's at stake with this initial hearing. And everything was fine here in Louisville for 5 or 6 months. People puttered along with Zoom eviction hearings. We all forgot to unmute ourselves and things like that. But in late January, the court made a decision, our understanding is, to upgrade their Zoom account. And they knew that they were going to lose the old phone number and access code that nobody, the landlord's attorneys, the legal aid attorneys, Ms. Harris here, and all of the people, the thousands of people that they had told, call this number, dial this access code on your hearing date, and that's how you appear at court. Nobody was going to have the right number. And instead of notifying everyone, providing the correct information to show up at your one-time only Zoom eviction hearing, the court just decided to enter evictions against people who didn't show up. If people called the clerk's office and finally made their way in, they would tell legal aid, they would tell the person to call legal aid and put it on a new docket to fix the errors that the court was making. So that's unacceptable. At about the same time, they upgraded the hearing number, changed the hearing room. They also updated the notice. And so now, instead of giving people the access code, the phone number for the clerk's office to call if they have any trouble accessing it, the court is now sending out a little slip of paper with the eviction notice that says, go to jeffersoncircuitcourt.com to find out what access code you need to call. And that's it. So we really have two problems, and we sued on two problems. One is the court's decision to move the eviction hearing room without telling all of the people who are facing eviction in a pandemic. It's, to me, common sense that violates people's due process rights without providing them with the updated, accurate information that they need to show up at their one-time Zoom eviction hearing. The next question is just providing people the web address and expecting them to go to the court's homepage and navigate to the remote court information page and find the eviction hearing information on that page proper and constitutional notice during a pandemic, when the risk of deprivation is so great, when we know that evictions are a public health issue, that African Americans and people of color are disproportionately impacted by evictions. All of these factors go into whether or not the court is doing enough to satisfy the very minimum standards set by the Constitution. And so we sued in federal court to hopefully protect people from unconstitutional processes, and that suit is still pending.
Thank you for sharing that. As you were speaking about this process and the move from in-person court appearances to virtual court appearances, I'm struck by the fact that when JCPS moved virtually, they sent Chromebooks out and hotspots out to make sure that all of their students would have access to the technology that they would need. Obviously, in our country, we have always had free access to our court system, right? And historically, if you had been, had an eviction suit filed against you, you would go to the courthouse, appear. When things moved virtual, was there is there a gap? Is there, how are these people who have these eviction suits filed against them, how do they get access to the technology to appear? And what if they don't have that access?
I think that's a great question. Your note that we've provided Chromebooks to people in JCPS sort of goes to my point that I make so often is home is obviously not just home anymore. It is sanctuary from a pandemic. It's also school. So why are we providing people with Chromebooks to go to school and not also providing people with Chromebooks so that they can stay in school by being in their home, right? Obviously we're at home now because home is the office for some of us. And so no, the short answer is no, we are not providing people Chromebooks. We are not doing anything of the sort.
Well,
but is there
can access court through a cell phone? You can call in to Zoom. You don't have to appear video. You can,
right.
If you have access to a telephone, you can call in.
Okay, that is maybe a subject of my privilege, that I only think about Zoom as video on my laptop, and I'm thinking about how difficult it would be to go through that process without having the same types of accesses that I have. So thank you for clarifying that, Ms. Avery.
I think
as with any of this, yeah, go for it, Gretchen.
No, I was just saying, one of the other things I think we need to still realize, even though I appreciate everything that Ben is doing regarding this federal lawsuit, there are still landlords who aren't complying with the simple notice requirement. That's been an issue since forever. I mean, the added part of not appearing in court, that's even worse. But sometimes the 14-day notice, the 7-day notice, the 30-day notice, it's not properly executed. And he acknowledged there was a case out of Louisville regarding the notice requirement. The illustrious Robert Smith was the legal aid attorney who took that to the Supreme Court and won the notice requirement. Back in the day, they were just posting them on doors and they were flying off. So people didn't get the notice they needed. So if you look at your realtor, you're required to either do in-hand service or send by certified mail. There has to be proof you gave people the proper notice, which you'd be surprised. I mean, people just think, well, no, they don't comply with it. So people don't know they're being evicted, particularly if it's for reasons other than non-payment. So, excuse me, courts require to have proof that you received it either by certified mail, or you can prove that you in-hand delivered it. I guess video if you take it with your phone, but I mean, we can't get compliance with that simple part. So, I mean, even before we make it to the video court, they haven't complied with the easy part to get to video court. And I think it's important that people need to realize they are required to receive proper notice for the court to have jurisdiction over the eviction to begin with. If the notice requirement's not met, that court doesn't have jurisdiction. So
to back that, particularly those initial, so 7-day and 14-day notices are not always received. And the thing about it representing tenants is you can't prove that you didn't get something. So you cannot prove that you did not get the notice. But what I have found is that if a landlord pulls out a piece of paper and says, well, this is a copy of what I sent, then they'll decide against the tenant every time.
I'm the only non-attorney here. And I think it's important to understand that all of these attorneys are sitting here talking about how complicated it is to just do the very basic. And I think it lends itself to the point that everyone should have counsel in the courtroom, that everybody needs an attorney to understand that in the courtroom. And I'm constantly amazed at the number of people who come to defend themselves in eviction court without counsel, because they're really on the verge of losing their home. And as a basic human right, we should have legal counsel for every person who's about to lose their home. That just should be a basic tenet of our country. I'm sorry, I just had to say that.
I don't
No,
argue with you.
I really appreciate everybody's comments. What I was going to add, it just seems that everything is, I guess, coming to a head. It's the perfect storm because we have Zoom court, and that's assuming that someone has a cell phone or a house phone to call. I would imagine, just given everything I've read and friends and family in my community, that people have lost their jobs. So if you're behind on your rent, what are the odds that you also have elected between food and paying your cell phone bill or paying your house bill? So, I mean, the broader question is access, but it seems to just be multifaceted if I'm understanding what everybody's comments are.
And poverty is real. I mean, it's been real before we had this pandemic, and poverty affects a lot of things. And I think housing is probably one of the most glaring issues that homeless, obviously homelessness and people who don't have the means to pay the rent. Not everyone can qualify for income-based housing, but that doesn't mean everyone can actually afford to pay rent. So I mean, it's a big deal. I mean, when we have minimum wage is $7.40, or is it $7.50? It's not very much, but if you do the simple math on that, you can't pay a month of rent with a person who makes minimum wage. So I think it's so many things that are wrong that lend to this eviction issue.
Yeah, and I think we have to, that we need to be a little forward thinking too. This pandemic's going to be over sometime before too long, hopefully. And Ms. Harris is not going to be sitting in eviction court offering to write checks because the federal government's not going to give money forever. But there's still going to be 60 or 70 evictions cases every day in court. And we need to be aware of that and thinking of solutions about what we can do. And Ms. Harris is absolutely right. A tenant cannot represent themselves in eviction court. They can right now because Ms. Harris will jump up and say, I'll pay their rent for them. But when the pandemic's over, they can't. There are defenses that can be raised, but they have to be raised correctly. And the counsel can raise that, an attorney can raise it for the tenants, or maybe even negotiate some kind of mutually beneficial solution for the landlord and the tenant. But a tenant who is in eviction court on their own, particularly in a non-pandemic time, is going to lose. So, get assistance, reach out for assistance because it is there.
Appearing in court is on Zoom, face-to-face like we are now, is complicated enough for people that understand technology. How many times, none of us are cats today, but it's complicated enough for us that kind of know technology. For those people that just call on the phone, I talk to people all the time that said, I was on the phone and I heard my name and they said something and then I don't know what happened. And can you tell me what happened? So that's a whole nother layer. When I'm looking at you all, I can kind of follow along, but just listening to a courtroom on a phone is really difficult. We do have now the courtroom is allowing people to come down to court, but the judges don't necessarily want them there because of the pandemic. But if someone shows up at court, the judges make them all wait outside and get their name, and then they will allow them into the courtroom. But the judges absolutely at that appearance give them a phone number and say, you can call in next time. And some tenants will say, no, I want to come. And some will say, okay, I'll do that. So, a lot of people have burner phones. They can't sit on court. I mean, I've been in court sometimes when it's gone till 12:30, 1 o'clock for an 11 o'clock docket. And you can't sit there for an hour and a half on a phone where you only have 60 minutes a month. So there's just a lot of challenges to the Zoom court. I just think that's important.
Mr. Pope, can you tell us how people can get an attorney if they need one?
Well, my suggestion would be that they can call legal aid. Our number is 584-1254. Everybody does have to be income qualified. We represent people up to 200% of the federal poverty level. But what I would say to everyone listening, that if you are having a problem paying your rent, I am almost sure you will qualify for our service. So I would say call us soon as you're having a problem, so that we can help you do the CDC forms, we can negotiate with your landlord. We can get you connected with the services from Metro government. And if somebody has an eviction filed, an active eviction case, if they're, we will take the case. We will take every case for people that call us. We've increased our housing staff, and we will not turn down anybody that calls that has a pending eviction case. We also, I will add on that, since we talked about the technology involved, we have set up in our office kind of, we call it a mobile courtroom, but in our conference rooms, they're now set up where the clients can come in. They've got their own computer. It's behind plexiglass. They can sit there and attend court. Our attorney will be there on the opposite side of the glass, and so they can actually have that access to the court and Zoom through our office.
And remember, all the libraries are closed. So a lot of people who would gain that access haven't been able to go get access to the library. So
right.
I do think that's a key point.
Yeah, that's one of the reasons we set that up, but we've had that since almost the beginning of the pandemic. So
that's a great setup. You mentioned the CDC declaration, and Mr. Carter, I know your Kentucky Equal Justice Center has the Home Center Declaration.org application, and I know I have totally butchered this, so I'm just going to turn it over to you. And if you could, I know we've had some questions as well about the CDC declaration, and if you could tell us a little bit about the CDC. I understand the CDC came out with an order, and it has kind of put a halt or tried to put a halt on evictions through March 31st, but my understanding is you have to fill out this form. One of the questions we had is, who qualifies to fill out that form? And then if you could talk a little bit about your app and how that helps people.
Sure. Right around the time that the CARES Act protections were expiring in late August, the CDC announced on September 1st, to everybody's surprise, that starting September 4th, they were going to try to protect people from eviction for non-payment of rent with a nationwide order. And the order requires people who rent their homes to fill out a declaration. It's a one-page declaration now, and it's just got a place for you to sign and date. And you have to swear that certain things are true, that you make less than $99,000 this year, that you have suffered a drop in income or some sickness, that you would have to double up or be homeless if you were evicted. And there are a few other things. You've tried to make partial payments or are willing to make partial payments, and that you've used your best efforts to track down rental assistance, wherever that might be in your neck of the woods, whatever rental assistance might be available, that you're doing your best under the circumstances to find rental assistance. I used to work at Legal Aid Society. Stewart was my boss. And as soon as we saw that there was going to be some kind of form to fill out, it immediately creates all sorts of access to justice issues. First of all, in order to get these protections, they're not automatic. You have to fill out a form, which means that you have to know that protections exist and then know to fill out the form. And we had been playing with some form building software during the COVID-19 pandemic. And this is really a dog that caught the car situation, where we knew how to help people generate documents, legal documents. And all of a sudden around the nation, there were hundreds of thousands, if not millions of people facing eviction with a high motivation to fill out a declaration if they could sign it truthfully. And so we built an app called homerenterdeclaration.com. Let me just explain home renter real quick. I'm a homeowner. This is my home. I reject labels like renter and tenant because it robs people who rent their homes of the idea that they have a home in the first place. We all have homes, whether they're rented or owned. And to call someone a home renter, I think accurately expresses what's at stake for them. in this process. So we created an app called homerenterdeclaration.org. You can go there and fill out the form. The other problems that this declaration creates is not just a publicity problem, realizing that you have to know about it. The libraries are closed. I have 2 printers at my house, half of them work, right? And so you might have a printer at your house. You might have access to the internet at your house to print it up and all of that stuff. Or you may not, which means a trip on TARC to Legal Aid Society or downtown, or I don't know where you would go right now. FedEx to pay $5 a page for them to print something up for you. At homerenterdeclaration.org, you can fill it out, sign it electronically, and if you know your landlord's email address, email it to them within the app, and you get a copy of it in your email inbox too. So I'm really gratified that like more than 3,000 Kentuckians have used the app, and more than 40,000 people across the nation have used that app. I wish that usage would go down, right? It hasn't. Did I answer your question?
You did, yes. Thank you so much. And, you know, one of the questions that we've received from Facebook related to this is what happens when a tenant files a CDC declaration or, you know, sends it to their landlord, but refuses to apply for assistance or make partial payments? What happens next?
You know, these things are enforced by the U.S. attorney's offices. So lying on a form is perjury, and landlords can refer people to the U.S. attorneys, I suppose.
I would just want to add to that, that when we tell someone, when we say to anybody who calls our office to fill out the CDC declaration, we explain to them that they need to continue to make attempts to pay whatever they can. And we also explain that a landlord, while they're going through the eviction process, can't accept it, but they need to make the offer because it shows good faith on their part. And we want to encourage them to do everything they can to show good faith that they are doing everything they can and complying with that CDC order.
I'd like to follow up with a couple of things too. First, it's important to note that the CDC order only applies for non-payment of rent. So it doesn't apply in any of the cases where somebody has breached the lease in another way, like playing their music too loud. And it doesn't apply to any of the cases, which are really coming up a lot now, where leases have it just expired, come to the end of the term. So so the CDC does not stop those evictions. And then, as somebody just said, we also, whenever anybody calls our office, we tell them about the CDC, but also encourage them, you know, that they have to use their best efforts to pay the rent. I mean, you know, we're not encouraging people to not pay their rent or to use the CDC as an excuse to not pay rent or try to get that rent paid. So we will help them with the CDC order while at the same time referring them to Ms. Harris or one of the other agencies that will pay rent.
I think it's really important to follow up on what Stewart said, to say some people call the CDC protections a moratorium, and that dramatically overstates how protective these provisions are. They become less protective each month because, as Stewart said, it doesn't protect people from eviction for overstaying a lease. So we have a situation common. We've told the courts about it. We've told Governor Beshear about it. We've told Greg Fisher about it. We've told POTUS about it, right? People whose landlords decide to terminate their lease, a month-to-month lease, because they can't pay rent, right? And so they're not evicting someone for being unable to pay rent, even though we know that evictions spread COVID, that tens of thousands of people have died across America because we did not halt evictions from March to November of last year. 400,000 people got COVID as a result of evictions. I'm not saying people who are evicted got COVID. I'm saying the people that those people were caring for in nursing homes or serving at the grocery store or something like that got COVID. Everybody is endangered by these evictions. It's, you know, in everyone's interest to limit them as much as possible. But we have a situation where you're not allowed to file evictions for non-payment of rent, but we allow landlords to create what is just a legal pretext to claim that the lease violation is something else, when really we all know that it's for non-payment of rent.
And I'm like, I'm
And
being
I think
forced to come to the defense of landlords a little bit here. And this is contrary to my regular nature as a young lawyer, but we can't, it's like we're almost forgetting. Like I said, I've been in this arena for 20 years, where there is an element that evictions are necessary. And I mean, we don't like to hear it, but sometimes it's the only option that truly exists in order to, all landlords aren't awful. All aren't great. They aren't all awful. I mean, I've got a case right now where literally the tenant is tearing the house down. Like literally windows broken, doors off hinges, tearing the house up. There's no question. It's not an issue of money because, you know, the rent we pay, she's tearing the house up. So, I mean, there has to be an element to rectify issues where there's truly damage being done and that the landlord is never going to be made whole on that. Shouldn't have the money to make him whole. So there has to be some safety net that does exist for the property owner to an extent that a tenant shouldn't just be able to take advantage of the situation. Now, having said that, most evictions that are before this court and they're, you know, currently that they're being impacted by this pandemic are usually due to poverty. It's not, you know, it's not necessarily as, you know, always a breach of the terms, but those do exist, and we need the courts to be open for that.
And it's just important to note, and I agree with Gretchen. There are times when, you know, there's no alternative other than to evict. But I mean, this is really a unique time. It's the only time in my career in which there has actually been money to pay rent for tenants who are not able to pay rent. And not only, you know, when we were looking at it last fall, there was money to pay back rent, but no guarantee for future rent. I can understand landlords being a little bit concerned about that. But now, not only can they get all of their back rent, they can get 3 months future rent. So, you know, I think that's just a good opportunity for landlords and hopefully people, home renters, as Ben corrected us, will be able to get back on their feet, and that time, and that the economy will loosen up and people will get back to work. And
you know, pre-pandemic, we did a few days of court survey pre-pandemic, and we were seeing about 97 or 98% of the cases were for non-payment of rent. And that's not like a scientific, I mean, it's not scientific, but we did just a few days sample, and that's what we were seeing. I'm going to say we're more about 80-20 right now, maybe even a little more than that, where 80% is non-payment, 20 is lease termination, holdover tenants. But what Stewart said is absolutely true. I mean, literally our office is giving away money. I've given away almost $1 million since February the 15th. Just paying back rent for 127 households through eviction. So there is money, back rent and future rent. And so I think that is important to understand that we are more than happy to pay to keep people in their housing. We want to keep people housed. We will do whatever we can to keep those people housed, because house is everything. Just like Ben said, our home is everything right now. It's our school, it's our place of worship, it's our office, it's our doctor's office. It's literally, it is everything to us these days. And it is a little disconcerting that we can sit in our home and evict people from theirs. And I think that is really an important note to understand. So we in my office want to do everything we can, and we will work with every tenant that we can possibly work with. And, you know, one of the requirements of the money is there has to be a nexus with COVID. And we are digging so deep to find that nexus sometimes. We are doing everything we can to find a nexus, because I personally believe that COVID affects people in ways that we will never, ever, ever begin to understand. I dealt with this man who was about 85 years old, and he was on Social Security. He gets Section 8, he's in assisted housing, and he would loan his son money every couple months. And right when the pandemic hit, he had loaned his son money, and he was counting on getting that money back. And his son lost his job and couldn't pay him back. That's a COVID-related loss of income as far as I'm concerned. So we want to help everybody that we can help. And we're doing everything we can.
Ms. Harris, that was great. And Sarah and I are corresponding because we think this is so important. Please tell everyone how they can contact you in your office and get the assistance that you're talking about.
So we have two programs that you can come through. The first one is the court eviction program. And what I say to everyone is go to stopmyeviction.org and do item number 1, which is the CDC eviction declaration. Do that today. And item number 2 is the Jefferson County eviction diversion form. And that gets you immediately into our program. And so if you are in court and you have a court case, those are the 2 things that I would advise you to do right now. If you do not have a court case, so your landlord has given you the 7-day notice that he has to give you, in order to cure the non-payment, go to stopmyeviction.org, do item number 1, which is the CDC declaration, and item number 3, and it says get support. And that support will get you into the area community ministries or the Louisville Rapid Access Network program. And I'm just going to tell you, the list is long. We have a tremendous amount of need in this community. And they've got literally 1,000 people in their queue. I've got 1,000 people in my queue. And they've already closed down the Office of Resilience and Community Services Neighborhood Place program. They have 5,000 people in their queue already. And so they have got appointments scheduled out through April 31st right now, 30th. I don't know how many days are in April. I never get that right. Whatever. So right now, the best way to get assistance is the area community ministries, item number 3 on stopmyeviction.org. And when the neighborhood places open back up for new appointments, because they will, we are getting more money and they will open up for new appointments. You could get to that link also through stopmyeviction.org. You can get to every link. And if you're outside of Louisville, if you go to stopmyeviction.org, down at the bottom, it tells you if you are in the bulk of the state, not Louisville, not Lexington, you would click on this link and it will take you directly to the state at large's application for rental assistance. If you're in Lexington listening to this, the Lexington link is there. So every resource we have for rental assistance that is affiliated with the emergency rental assistance program by the federal government is listed on stopmyeviction.org for the state of Kentucky.
So in follow up to that, Ms. Harris, I know that there's a deadline or perhaps maybe a cutoff, at least with respect to the CDC, of March 31st. Is there any discussion about extending that first and foremost? And then the second part is, Ben, you referenced earlier talks with our local government and maybe federal government officials about late termination of a lease not related to non-payment. Is there any inkling perhaps that there's going to be some legislation on that to address it?
Well, I'm going to let Ben answer the second part, but I'm going to answer the first part because I literally just had an email from HUD today asking some questions about what we're seeing and what we think. And frankly, I'm very hopeful that we get an extension of that eviction moratorium. I think sorry, Ben, I don't know what to call it if I don't call it the moratorium, but the CDC declaration. I'm very hopeful that we get that extension, for some time forward. I don't know when we're going to be out of this pandemic. They keep saying herd immunity is like 90%, and I think we're a long way away from 90% of the people being inoculated, vaccinated, or having had it and having immunity. So I don't know when we're going to be out of this, but if we want to keep people alive, especially the lowest income people in our community, we need to have that extended so that we can keep people housed. And we need to fix the loophole that allows them to do lease termination for a holdover tenant. And you know, we can pay the rent, so we want to pay the rent. So we want to make sure landlords get the money, because the other thing we don't want is any landlord going belly up on a deal, on a unit. We don't want, you know, there's this misconception that landlords are rolling in dough, you know, that they just are throwing money around, you know, they're out there just whipping money around. That's not the way it is, especially low income properties. So if you have a unit that is subsidized in any way, shape, or form, those operate on a basis of about 1.15 debt coverage ratio. That is extremely tight. That I was a property manager for 3 years, a regional manager. I had one property out of 27 that ever in those 3 years cash flowed greater than 1.0. Literally, they just don't cash flow. And that money comes directly out of the developer's pocket. So, so we don't want to see a development go belly up because the landlord didn't get paid. And I don't want to see the mom and pop landlord who own 2 or 3 or 1 unit, you know, that's their retirement income. We don't want to see that either. So we don't want to see people unhoused, and we don't want to see any housing units taken off the market. So the best thing that we can do from my office is to pay the landlord on behalf of the tenant, so the tenant is insured to have housing. And I do want to say that the only reason we can do 3 months forward is because the federal statute that we are operating under only gave us permission to go 3 months forward. If I could go 6 months, I would easily go 6 months forward, because otherwise I'm just going to be reprocessing these people. Come July 1, I'm just going to start processing these people for another 3 months worth of assistance. So, okay.
Ben, or Mr. Carter, I think the floor is yours to answer the question about potential legislation.
Yeah, we're not going to see any legislation from this General Assembly on this. I think there's the potential for an extension, like Ms. Harris discussed. We're 2 weeks away from the deadline, and these protections were originally supposed to expire December 31st. Then last minute they were extended to January 31st, and then President Biden extended them to March 31st at the very end of January. And what I think people don't appreciate is that people are making decisions right now about what they need to do when these evictions protections are expiring in 2 weeks. And so the lack of information is really damaging and dangerous. We want President Biden to extend it. We are still very much in the middle of this pandemic, and the growth of the more contagious variants is something that we all need to work to suppress. And we are just now getting all of these rental assistance funds from the December bill and the recently passed American Rescue Plan online and in our communities and pumping out the doors. So we need to extend it. If President Biden isn't going to extend it, he needs to say that too, because people need to be able to plan, not just the people facing eviction, everybody on this call, all of the landlords, all of the landlords' attorneys, the courts, they all need to know what the story is. We hope that other elected officials will take action if President Biden doesn't, to make sure that Kentuckians can say healthy at home, whether home is rented or owned. So I've been really disappointed, just for the record, that President Biden has not closed some of the obvious gaps that we expected to be closed. For a long time, I was calling this loophole a loophole, right? This ability for landlords to terminate lease terms and kick people out during the middle of a pandemic, when it's really about non-payment of rent. I considered that a loophole that the previous administration just didn't care to change. I expected President Biden to close that loophole, and in 2 months in office, he has not. And so we can't call it a loophole anymore. We have to acknowledge that the system is working as President Biden and all of these elected officials want it to. And so we have to come to terms with the fact that President Biden thinks it's okay to evict people for non-payment of rent by ginning up some legal pretext. I disagree with that. I hope he extends the moratorium and expands the moratorium so that we can go back to calling it a moratorium. Because right now we just have to call it eviction protections. It needs to be expanded and extended so that everybody can stay healthy at home.
Mr. Carter, I want to follow up on that, and then I want to hear from Ms. Harris and Mr. Pope as well on this, and Ms. Avery, if you have something to add. What happens on March 31st? Do we have a sense of whether or not things have really been held back by these eviction protections and there will be a flood of eviction proceedings moving forward? Or I get the impression from our conversation that court has been continuing to move forward. Evictions have been continued to be filed despite our maybe lay description of it as a moratorium when it is not actually, prohibiting evictions from moving forward. So what do we anticipate happening if for some reason it's not extended on March 31st? What happens on April 1st? What do we think?
Well, I think what happens is that there's a specific court date, April 9th, which is the CDC court date. All the cases have been continued to that day. In a meeting earlier today, I think Ms. Harris said there were already over 100 cases on that docket. So that's got cases where either landlords were not accepting rental assistance. It also had some cases where that involved subsidized housing, but I think Ms. Harris said that they have actually paid a number of those cases. So some of those cases will be dismissed because payments have been made and it just hasn't been reviewed by the court. But otherwise, if the issue is non-payment and the eviction was stopped because of the CDC declaration and payment still hasn't been made, then those people will be evicted on April 9th.
I can tell you that during the last few weeks, if an attorney for a landlord says a CDC has been ordered and has been entered, and the landlord is willing to work with us and accept the rent, then they're not passing it to the CDC date. They're passing it to the regular, whatever. Right now they're using a 4-week pass so we can get the funds out the door, which I'm almost ashamed to say is taking us much longer than I would like it to take us. But the new Treasury guidance has some provisions in it that make it particularly difficult. We now have to certify everyone's income and we have to collect that kind of documentation, which from a client services point of view is particularly difficult, especially people who are at risk of losing their home. Most of these people, they're unable to put their hands on their last 8 paycheck stubs. I mean, can you put your hands on the last 8 paycheck stubs right now? I can't. So now I want to pay your rent, but you have to give me the last 8 paycheck stubs you've had. That's a particularly difficult task for people to do. So the courts have been really, really great about giving us leeway, getting the money out the door. But quite frankly, I understand the landlord's point of view that that's just way too long. And I know it's way too long. And the only consolation I have for the landlord is that if we get close to the next month and we say if we haven't executed the contract before 7 days before the next month, we will add that next month on. So you'll get, so right now, if I don't execute the contract or write the check until say March 27th, I'm going to add April's rent on as a current benefit. And then I'm going to do May, June, and July. So I'll pay that full. So you get 3 full months of future benefits for that tenant once you get the rent in your hand as the landlord. I know that's not a lot of consolation because mortgage companies aren't holding off on making, you make payment, but it is the best we can do at this given moment. So evictions are still going on. We see them every day. And some dockets are incredibly long. But I will say that if the CDC has been ordered and the landlord is willing to work with us, then that has just been going through the process, and we have been trying to get those cleared up and off the docket. The other thing is that if a case gets paid, a landlord, the attorney for the landlord can always submit that dismissal prior to court. But a lot of attorneys don't do that. They just wait to get into court, and then they just say, Your Honor, we can dismiss this. Today there were probably 40 dismissals that could have been dismissed previously through the system, and they just weren't until we got into court.
Yeah, I think that the April 9th date is the date for cases where rental assistance is not being accepted or whatever. So that particular day potentially will see a lot of evictions, because those are the cases where rental assistance is not an option.
And there are 101 cases on that docket as of today.
I want to switch gears just a little bit to think about this problem from the perspective of the landlord. There's no doubt in my mind that there are far too many people that need assistance right now during this time due to the pandemic and just everything that comes along with it. There has been some criticism of the moratorium, and there has been some argument made that there are people who are abusing, so to speak, the rental assistance. Do you believe that potentially plays a role in this? And what would you say to those who are arguing that, people have received stimulus checks, people have found a way to pay car payments or purchase new items for their home, but they're choosing not to spend the money on rent?
I mean, you always have an argument. It's always the argument that, like I said, I think it all goes back to poverty. If you go to any eviction court in a non-pandemic time, very seldom do you see someone who's gainfully employed making plenty of money in an eviction court, unless it's a business and it's a commercial situation going on. But the average person at the eviction court isn't flush with cash. I mean, it's, I think we always police how poor people spend money and don't want to recognize that they don't have enough money to start with. I mean, I'm getting on my soapbox about this minimum wage, but I think it really comes down to that. We can talk all day long about rental assistance and all these things, but the pandemic goes away, the money goes away, and we're back at square one regarding why rents aren't being paid. And it's usually because there's no money. So sure, you'll have people that say, they're spending money on stimulus, but if you truly don't have rent money, you probably didn't have money to pay anything else. You're struggling with food, you're struggling with utilities, you're struggling with just the everyday things that some people take for granted. So we can say all day long, oh, they're wasting their stimulus money. Okay, but still, they don't make enough money to pay the rent. I mean, it's really just that simple. But we want to create it. Everyone wants to dress up as it's something different, when it's really just a matter of rents don't match pay. You look at the average pay, the average rents, they're far apart. So until we fix that real problem, we're always going to have the issue of eviction court. Maybe not during a pandemic time, but we're going to have the issue of people being evicted from their homes, becoming homeless, and then what are we going to do then?
So the stimulus payment, I'm sorry, Stewart, the stimulus payment that people just got like last weekend, $1,400. The average amount of past due rent is about $3,500. And in Kentucky, the landlord can't take $1,400 if they've got an eviction and they owe $3,500 because it cancels the eviction. So quite frankly, I'm telling them, keep your money, keep it in your pocket. Let me pay your full amount, because I don't know when this pandemic is going to end. I want to pay all of it, and you use that to feed your family.
Yeah, I mean, that's absolutely right. I've been at legal aid for 21 years, and it's not uncommon for me to get somebody to complain, opposing counsel or something, complain and say, oh, that person makes too much money to be qualified for legal aid. And, it's absolutely not true. Every client we get is struggling. And I have found that they don't lie about their income. We don't necessarily, we don't make them prove their income. They don't have to produce tax returns or whatever. But in some cases, like if we're doing a divorce case or bankruptcy, they do have to present a proof of income to present to the court. And our clients don't lie about their income. They're not rolling in this money and buying new cars and all kinds of luxury goods and things like that. It's just not happening. I think that's, I don't know, sometimes I feel like people that make those kind of criticisms just want to deny the benefit, but, you know, just don't want to say, I'm being mean about it. You know, they're misusing the money. That's absolutely, you know, absolutely not true. The same way that you know, somebody might say, oh, they just want to live off of welfare. You know, really, they want to live off of $700 of SSI a month. I don't think so.
I
It is
will
a
say
total
that-
myth
Yeah, right.
that people are buying cars or, you know, buying televisions and not paying rent right now, in the same way that it's a total myth that people are perjuring themselves on the CDC declaration in order to stay in their homes. I said in the chat on Facebook Live, I'm a landlord. Marilyn Harris's office has paid one of my home renters rent for a couple of months. Everybody is having a hard time here. I'm not anti-landlord, I am a landlord. If somebody is working at Facebook, coding for Facebook out of their apartment in Covington, and they want to not pay their rent, that landlord has had the ability to sue that person in court for breach of contract and get a judgment against them and can garnish their wages throughout the pandemic. That has always been an option. So the courts have never been closed to landlords for that purpose. And so when we have millions of dollars in rental assistance, when the courts are open for those very rare, I would say non-existent cases where people can't pay or can pay but aren't paying, just decide not to pay and risk damage to their credit, an eviction on their record, all of those things, you know, the courts have been open for remedies for those folks that don't exist.
I would, let me just add, somebody's asked the question, how many times can a person utilize the services? And I think that's important to answer before we move on. The current regulations allow us to provide a full 12 months worth of past rental assistance. So that is April to March. So I can pay 100% of the past, and I wrote one yesterday. So we'll pay everything that is due from April to March. And then I can provide up to 3 months forward at a time. And that's important, at a time. So I can provide 3 months. So I write that check today. It pays rent through June. Come July 1, that tenant can get assistance for July, August, and September. And then October 1st, I can pay another 3 months, October, November, and December. So there is no maximum limit to how many times they can apply, but I can only give them assistance 3 months at a time without re-verifying their income. And I am encouraging everyone that I work with, if you know July 1 is going to roll around and you are going to have trouble, you need to get an appointment and get back into the system, because there's nothing to say we actually can pay rent forward without having to pay any arrearages. So you don't have to get to eviction court to get assistance. You can apply at stopmyeviction.org and they can pay that 3 months before your landlord has to take you to court. And we encourage everyone to do that. When you know you're not going to be able to pay it, get on there and make that appointment, register so that we can help you before the landlord has to take you to court. We don't want anybody in court, because quite frankly, as soon as that landlord files that eviction in court, it shows up on your credit. Whether it's dismissed or not, it's there. It's there. It's going to show up as dismissed, but it's going to be there. And when the next landlord comes through and pulls your credit, because that's what they do, and they're going to see that eviction, they're going to think twice about renting to you. Even if it was dismissed, they're going to think twice about it. And I am not anti-landlord either. I too am a landlord. So I'm a landlord, but I am also an advocate for people to remain housed.
And I just want to reiterate to everyone watching, the two websites that we have mentioned several times, they're very important, is stopmyeviction.org, homeownerdeclaration.org, please look on your screen and write down the names of the panelists that you are seeing. They are fantastic in their fields. We've got Miss Avery, she's in private practice. Stewart Pope, he is with Legal Aid Society. Ben Carter used to be with Legal Aid Society and now he has his own practice. There are resources out here. Please do not hesitate to reach out. I just think tonight has been fantastic. I'm not wrapping this up, but I just feel compelled to say I wasn't aware of all of the resources out there. And if I didn't know, I'm sure there are tons of others that didn't know as well. And the reason that this forum was important to Sarah and I personally, as well as our respective organizations, is just because we know the pandemic has just shined a light on an issue that is long overdue in terms of being addressed. And I personally thank each and every one of you for the work that you're doing. I just think it's phenomenal. So I couldn't wait until the end to say that. I just hats off to each and every one of you. I'm just overwhelmed.
Thank you, Michelle, for sharing those thoughts. I absolutely agree with what you said. It has been a very engaging conversation and I appreciate it from everyone. A reminder to our audience, we are going to be wrapping up pretty soon. So if you have any more questions, please put them in the Facebook comments and we'll get to them if we can. We have a couple of questions that we have received that we have not answered yet. Ms. Avery, I'm going to send this one to you to start with and then open it up to everyone else. A question has been asked: if a lease is coming to an end and a tenant wants to renew, but the landlord does not, is there any protection for the tenant? And I know we've talked several times about this tenant, the lease term problem coming up, now becoming 20% of the docket in these cases. Is there anything a tenant can do in that situation?
No, at least it's a contract. And when the contract ends, the landlord or the tenant's not obligated to renew it. Just like if the landlord says, no, I want you to renew this lease, the tenant could say no. The landlord's allowed to say no. Obviously, that's been a tool that Mr. Pope and Mr. Carter believe is being used to avoid the non-payment eviction issue. But a contract is a contract. And once it's completed, neither party is obligated to renew it, as long as proper notice is given too. I mean, if a person just stays there, they still have to give them proper notice to get them out, but there's no obligation to renew it.
Thank you. The other question that's been asked, and I have no information on this, and I do not know if any of our panelists will. There was a comment made that the Home of the Innocents lost grant funding, and there was a question about how tenants can avoid eviction related to this. And so I'll just throw it out to our panelists if anyone has information on that particular issue.
I don't know anything about the Home of the Innocents losing housing. But what I can tell you is that if you are moving, if you are at a lease termination, I'm sorry, my dogs are going crazy. If you are at lease termination and your landlord is not opting to renew your lease, the Coalition for the Homeless has funds to help pay a security deposit and first month's rent for you to find new housing. I will tell you that moving is very expensive. And the people who can least afford to move are the people who move the most, which is our low income people. And they're constantly moving. And it's a burden, it's a drain. And so the Coalition for the Homeless can provide security deposit and first month's rent for new housing if you have gotten to the end of your lease contract and your landlord is opting not to renew, or if you've gotten into court, you've made it to court and the landlord says they're not going to accept the rent, we can provide assistance there. So any tenant at the Home of the Innocents who might be losing rent due to a loss of income, and I don't know anything about that, but now I'm going to tomorrow reach out to find out what's going on. They would be eligible for this program also. So if we can, if they want to apply, we can see if we can figure out a nexus with COVID and get them in and get them some rental assistance so they remain housed.
Great, thank you so much for that response. We have not received any other questions. I don't have any other questions. Unfortunately, Michelle got kicked off. I'm sure she's going to try to get back on and hopefully she'll be back on before we completely wrap up. I want to turn it over to you all. If you all have any final parting comments that you would like to make, Any final advice for either tenants or landlords going through this process? Final thoughts that you want to leave with everyone? Ms. Harris, we'll start with you.
I would say if you are a tenant, the first thing that I would tell you is to show up in court. You get your notice, show up in court, because we are operating under a Supreme Court order to provide this eviction diversion program, which I absolutely love. I just want to tell you, it's a little like Santa Claus. We're just giving money away. But you have to show up in court. Now we have some landlords that if they don't show up in court, they're still willing to work with us. And so we'll reach out to the tenant and see if we can't get the tenant to apply. So, but you have to show up in court, because failure to show up in court, just like Ben said, it's an automatic judgment against you. The other thing I want to say is, even if you have vacated the premises, right? So you get the notice and you're like, okay, I'm done, I'm gone, I'm going to pack up and I'm going to leave. And you vacate and you've gotten that court notice. If you don't show up in court, you get a default judgment. And really, eviction court is really only about who has legal right to be in the premises. And if you're already gone, you shouldn't get an eviction against you. So it's really critical that if you move out, that you show up in court and say, well, I'm not living there. I mean, I've seen cases where people have called, they've called into court and they've, the judge is like, okay, what are you going to do? And they're like, well, I moved last month. I live in Florida now. And the judge is like, well, hold on. If you've moved, we're going to dismiss this, because it's really only about who can live there. So I do think it's really important to understand that you've got to show up so that you can be your own best advocate and make sure that the outcome is the best for you. So I just say that, just show up in court. There are people there to help you. Legal aid, while not soliciting business, they do have Ashcon is there every day, and he will provide you the link and information you need to access legal aid services. So just show up in court. That's one of my big banners, show up in court. And I would really be remiss if I didn't shout out to the area community ministries for all of their work processing these, but also stopmyeviction.org, because that is their kind of brainchild. And it is amazing. First of all, it's so much easier to say, go to stopmyeviction.org than for me to say, go to louisvilleki.gov/housing// Look, stopmyeviction.org. That's what everybody needs to know. Everything is there. So that's my spiel.
Great. Thank you so much. Great advice from the perspective as a lawyer, right? Miss Avery, what are your final parting thoughts?
I think every tenant and every landlord should familiarize themselves with how the law works regarding evictions. The law has only changed slightly regarding, well, the law hasn't changed at all. The moratorium has impacted the law slightly, but the laws are still the same during a pandemic or not during a pandemic. Familiarize yourself with those requirements so that you can best represent yourself if you're not having a counsel, or at least know how the process works. And the knowledge of that will help, impact the eviction and the result that may come from it.
Thank you so much. And Mr. Pope and Mr. Carter, I will get to you on your final comments, but we had one more question come in. It's a question that we touched on a little bit earlier, but I want to answer it. The question is regarding Section 8 vouchers. If a landlord will not accept an 811 or Section 8 voucher, is this considered discrimination or protected by castle law? And I think, Ms. Harris, you mentioned earlier that effective March 1st, it is now illegal to fail to accept that. Is that correct?
It is a new ordinance within Louisville, Jefferson County, and it is illegal as source of income. So you cannot discriminate in housing based on source of income. So you also cannot discriminate based on veteran status, source of income, and I forget the third one, and I should know it. Does anybody know the third one? I don't remember. I don't remember the third one. I'm sorry. I was so excited about source of income that I don't remember the other two. So I'll just have to throw that out there. And I would say that if you have been discriminated, or you feel like you have been discriminated, you could always call legal aid, or you could call the Fair Housing Council. They're actually in Lexington, but they cover the entire state. So it's the Lexington Fair Housing Council, but they cover the entire state. And if you need To know how to get a hold of them, you can always call my office, 574-3737.
Perfect. Thank you so much. All right, now back to our final comments. Mr. Pope, what are your parting comments?
Okay, first, following up on what Ms. Harris said, if you do feel like you've been discriminated against, call Lexington Fair Housing. We refer all of our discrimination cases to Lexington Fair Housing, so that'll save you one call. The other thing I would say is I totally agree with what Ms. Harris said, that you absolutely must show up in court. I would encourage you to show up with representation, which you can get through Legal Aid Society. But I would also encourage you to start early. If you know that you're going to have a problem paying your rent, or you've already had a problem paying rent, don't wait until your landlord actually files an eviction. Go to stopmyeviction.org, start the paperwork. It takes time to process. And if your landlord's willing to work with you, then get the paperwork going and everything, and you know, try not to ever get to court, but you know, just start earlier. The earlier you start, the easier it is to resolve. And it's easier that if we're negotiating for you, the easier it is for us to do too, to have a little time to work with the landlord's attorneys rather than you know, get the case the day before court and not have time to negotiate.
Great, thank you so much. And finally, last but not least, Mr. Carter, what are your parting comments?
Yeah, I think what I would like for people to reflect on is, from my perspective, it seems like we are not near the end of all of this. I hate to be the bearer of bad news. I think we're going to get the virus under control, but the fallout from more than a year-long pandemic is going to be tremendous, especially on the lowest income members of our community. And so to me, it feels like we are at the beginning of the middle. And I'm still hopeful that we are going to be able to get processes in place, whether ordered by the president, by the governor, by our courts, legislated by our mayor, or agreed upon as a community, right? That reflect the enhanced interest that everyone has in people staying in their homes, if at all possible. One of the interesting things about the case Green versus Lindsay out of Louisville in the 80s was that nothing had really changed about the law and the notices that were being required. What the Supreme Court said was, housing is a very important interest in people's lives, and the fact that we're using outmoded means of service means that because the interest has grown, the importance of a thing has grown. It's become more less affordable. The damage to your credit can last for years. And now, obviously, the enhanced interests in keeping your kid in school, being able to do your job remotely, all of those things. It was unconstitutional what we were doing in the 80s, not because we had changed the law, but because the interest had increased in housing. And we're in the same situation right now. And so I hope that we can continue to work with all of these great people on the call and our courts and our elected officials to get processes in place that recognize the very dangerous public health ongoing issue that we have. Also, all of the rental assistance that's available, right? We have solutions to this problem that was a crisis before the pandemic ever hit, because we're in a pandemic, and we have to work together as a community to fix that. And I'm still hopeful that we're going to get there.
Thank you so much. And thank you again to all of our panelists. And I want to thank Michelle and the Charles W. Anderson Jr. Bar Association for their collaboration with the Louisville Bar Association Public Service Committee. This is just a continuation of our series, and we will look to have additional programs in the future regarding domestic violence and probate, just to name a couple that we're working on. So if you found tonight's information helpful, please continue to look out for more in this series. And thank you again to our panelists. And Michelle, do you have any final remarks you'd like to make?
I don't. Thank you guys. I again echo everything that Sarah said and just want to reiterate my comments earlier. I think the panel tonight was fantastic. I really feel like just hearing from people makes a difference in terms of knowing where to go, what to do. There is help out there. I think face-to-face interaction we're all missing right now. So I hope everybody enjoyed the panel tonight.
Thank you guys. Have a great evening.